All right, to explain a little bit more and explore some of those issues that John Webb and I were discussing, I'm happy to say I'm being rejoined by Chris Greenland, former Zimbabwean High Court judge. When we ended off our discussion a little earlier on, we were about to actually focus on this email. Yes. Explain it then, I mean, as a former High Court judge, is it admissible, is it inadmissible? And it does seem also to be part of the reason we have this delay.
Okay. Just before we go there, I just want to make sure that I pronounced the name of the serial killer that I said had a more glowing profile than Oscar. His name was Jeffrey Dahmer. Jeffrey Dahmer. Okay, to answer your question, as regards this email from the lady in Kent, it's inadmissible in terms of very, very well-established rules of evidence. And we've spoken about this on the program before. But, you know, I think Harry Nell should have just said to the judge and said to the opposing counsel, if you're seeking to prove that a person in Oscar's situation, a person with his challenges, physical challenges, has a heightened fight response, the state accepts that. I think, Bongani, you will agree. Nobody is going to disagree with that. Obviously, if you are a disabled person, you feel more vulnerable as a human being. So I think that's what Harry should have done.
I mean, it does appear that Kenny Aldridge anticipated Harry Nell's objection, and he's gone to some length and some detail in pointing out case law that he says supports the admissibility of this email. Do you buy Kenny Aldridge's argument there?
I don't.
Why not?
At the same time, I would accept that there might be case law which recognize extraordinary circumstances where you might admit this type of evidence. I'm not familiar with the cases that he cited. I don't have access to them. But nobody would be more shocked than me if this court were to allow that type of evidence.
Well, explain it to someone who doesn't understand these things. You know, one of the arguments that Harry Nell was saying was that I understand that hearsay evidence can, in certain circumstances, be allowed for an expert witness. Yeah. Well, when is it and when is it not?
Well, if you take the email, the lady in Kent was giving an opinion as to how a disabled person will respond in a situation of perceived or actual danger. That is expert evidence. You and I, when we go to court, are not permitted to give our opinions unless we are an expert in the field relating to the opinion that we're giving. That's a basic fundamental rule of law. The other objection is that you are never allowed to come to court and give evidence as to what somebody else told you. It's called hearsay. It's not admissible as evidence. And Harry Nell pointed out that one of the reasons it's not admissible is that he doesn't have access to the witness in order to cross-examine her on her evidence, on her hearsay, and on her conclusions.
But couldn't Professor Derman say that as an expert in his field, particularly dealing with disability and disabled athletes in particular, could he not say this is as valuable as any anecdotal evidence I might have garnered from interviews with people in Oscar Pistorius' situation? I'm just simply quoting it for the court in this instance.
Yes, Derman can say that, and experts rely on hearsay. Perhaps 95%. They rely on expert reports and the results of investigations and all that. That's not what was happening here. Defense counsel was wanting to read, quote, and lead an email that he received from another human being.
Sure. My question is, how is that different from an interview that Professor Derman might have had with various disabled people into coming to a particular conclusion?
Because it's not Derman that's proffering the evidence, if you might call it that. It's not Derman that's proffering this information to support Derman's conclusions. This is it Kenny Aldridge that is proffering this. He's not an expert. He's not a witness. He's defense counsel.
Well, let's see what happens. Let's see how Judge Masipa is going to rule on this issue, because court is back and to Pretoria we go.
The defense has sought to introduce certain evidence which counsel for the state has objected to. The basis of the objection is twofold. One, that it is hearsay evidence and therefore inadmissible. And two, that it is in any event irrelevant and for that reason inadmissible. Counsel for the defense has argued that the piece of evidence sought to be introduced is neither hearsay nor irrelevant. But before I go to the argument of counsel for the defense, I need to state that to determine this issue properly, it is necessary to scrutinize the nature of this evidence. The evidence concerned is to be found on pages 27 to 30 of an expert report compiled by Professor Wayne Damon. Professor Damon is currently in the witness box giving evidence on behalf of the defense. The evidence consists of two emails from two individuals who appear to have physical disabilities similar to those of the accused in this matter. Counsel for the defense submitted that the piece of evidence objected to was not hearsay, as the two emails were not tendered to establish the truth of the contents. He also further argued that the courts usually accept experts' reports, such as those of psychologists who have used different sources to compile their reports and make findings. It is so that courts usually accept the sources that are consulted by experts will not come to court and therefore cannot be cross-examined. The distinguishing feature between those instances and the present case is that the sources consulted by experts such as psychologists, probation officers, and other experts who compile pre-sentencing reports give light about personal circumstances of the accused. In the present case, the sources, that is the two individuals already referred to above, refer to their own circumstances. The circumstances of these two people cannot be relevant in this case. Counsel for the defense referred to the matter of Lorna Dawn Investments Pty Limited versus Minister Van Landbouw 1977, Volume 3, SA 618, capital T in bracket. I am of the view that this case, that is the case of Lorna Dawn, does not assist the defense in this argument, and I shall read a portion of an extract in the case that was referred to by defense counsel on page 5 of page 10. The judge in this matter, that is in the Lorna Dawn investment matter, quoted Watermeyer in R versus Miller, 1939 AD 106, page 119. ... No, I rephrase, it's got to be in brackets, no, in quotation marks first, and then ... If, on the other hand, they attended for their circumstantial value to prove something other than the truth of what is asserted, then they are admissible if what, and I want to emphasize this, if what they attended to prove is relevant to the inquiry, close quote. Defense counsel's argument seems to have overlooked that condition, that the evidence will only be admissible, I quote, if what is tended to prove, what it is tended to prove is relevant to the inquiry, close quote. Defense counsel has not stated why the evidence is relevant, well, at least not in a manner that could persuade me. Instead, he submitted that should this court find that the evidence is hearsay, then it should be admitted under the exception rule, and the court should allow counsel to argue its probative value later. I think such an exercise would be fruitless. I am not even going to entertain it for the reasons that I have already said. The evidence is not relevant. Counsel for the state correctly argued that the purpose for which the evidence is tendered is strange. I agree. One cannot use the evidence to support and supplement the report and still claim that the emails are not used to establish the truth of the contents. For the above reasons, the objection by counsel for the state is sustained. My finding is that the two emails from pages 27 to 30 by Professor Demon of Professor Demon's report are hearsay evidence and irrelevant. They are therefore not admissible. In addition, I order that the portion of the email on page 27, which has already been read into the record, be expunged from the record.
As the court pleases.
As the court pleases.